Hello, what am I going on in here again? And Bernard the Barrister Bear. Hello! And this is a continuation of the last video called Disarray Part 1. This is Disarray Part 2. Because you may recall, we were talking about the case of the 126 young women and a few men who had been sexually abused, assaulted by Dr. Bates, who examined them, he was supposed to examine them and did reports on them, medical reports, on behalf of Barclays Bank. The two first courts that heard it, the High Court and the Court of Appeal, found in favour of the 126 claimants, but the UK Supreme Court reversed that and said, no, Barclays Bank was not vicariously liable for Dr. Bates's misdeeds because he wasn't an employee or was not in a role akin to that of an employee, because that's what the lower courts had said, that he was in a role akin to an employee. They knew that he wasn't actually an employee, but he was acting as if he was an employee. That's what they said. But the Supreme Court said no, he wasn't, because he had his own independent practice as an NHS GP, and he was operating from his own home, surgery, and he wasn't paid a salary or a retainer. He was paid per individual report. Therefore, he wasn't acting remotely like an employee. But what they didn't consider was that he was acting as an agent. He certainly must have been acting as an agent if he wasn't acting as an employee. How one can avoid that conclusion, I don't know. But it wasn't even discussed, wasn't even considered. And yet, if Dr. Bates was acting as an agent of the bank, that would make the bank liable just as much as if Dr. Bates was an employee. The law in this whole area is in disarray. Disarray. Now I'll just read you what Lord Neuberger, retired now as President of the UK Supreme Court, said. Analysis of tort cases appears to demonstrate a notable degree of disarray and a marked lack of reliable principle. Disarray and lack of principle? Gosh, can we really be talking about law? Disarray means disorder. Mess. Law is in a mess. And lacking principle, surely that should be the basis of law. But, and of course he's talking about the whole area of tort here, not talking about this individual case, but generally, which is particularly worrying, the whole area of tort, including the whole area of negligence, most road traffic cases, professional negligence, all kinds of negligence, fraud. It's a huge area. It's the biggest area of the civil law. That means the law other than criminal law. By far the biggest. And if there's a lack of principle, and if the law is in disarray, what does that really mean? It means it's unpredictable. It means, essentially, that when you walk into court, and you take a case to court, you are basically rolling the dice. Because there are no rules. Lack of certainty and predictability is what we're talking about here. Lack of certainty and predictability. Surely that should be the basis of law. And of course, this is why so many cases have gone on appeal And like this case, it's not by any means the only case of its kind, but it went all the way to the UK Supreme Court. Because at each level, you don't know what the next level is going to say. So because the law is so uncertain, you might as well try, if you've got the funds, and that is where the problem lies, because under English law, it's, as far as I know, it's the worst system for costs, the worst jurisdiction as far as punitive costs are concerned, because the loser pays the winner's costs, and the loser at the end pays the winner's costs up, all the way up and all the way down. Even if you won the first 2 rounds, if you lose the last round, you have got to pay the costs of the winning party at the end, all the way up and all the way down, even if you won in the first 2 rounds. And that was what happened here in that case with the 126 claimants against Barclays Bank. Another common pattern, unfortunately, is what I call a yo-yo case, where you get one party winning at first instance, then losing on appeal, and winning finally again in the final appeal. And that one, that party that wins in the final appeal, and which had won initially as well, gets all the costs up and down again. But why is it necessary to have all these appeals? Precisely because the law is so uncertain. And why is the law so uncertain? It's because, essentially, Parliament, which is supposed to be in charge of legislation, hasn't done its job. So I don't blame the judges. What has happened here is that Parliament, which under the British Constitution is sovereign, or what that really means, Parliament has legislative supremacy, but although it passes hundreds and hundreds of laws every year, it doesn't pass basic laws to guide the courts. Where are the laws governing tort generally, or vicarious liability? You won't find them. Yes, tiny little islands of laws dealing with one tiny aspect possibly. But the idea of having laws which cover whole areas, consolidated, we talk about consolidated laws, are rare, and much rarer still are codified laws. For some reason, in Britain, the legislature has fought shy of codifying the law. That means turning the law into a coherent whole. Yet in America, which is also supposed to be based on the common law, supposed to be the similar system, every single state has its own codified laws. Most of them are very similar to one another, but they're codified. Even a tiny state like Wyoming, with a population of 500,000, has got a codified system of laws. Why is there no such system here? Because then, at least, the judges would be given guidance on what the law is. The way it is now, there's a vacuum. And so the individual judges step into that vacuum. Not their fault, but there is a vacuum. And they then decide what the law is. It's not their job to do that. They're not legislators. Parliament is supposed to be the legislator par excellence. Of course, Parliament doesn't act on its own. Parliament in our system is essentially under the control of the government, because the government emerges from Parliament, majority party in Parliament, and so when we say Parliament, what we really mean is the government actually passing legislation through Parliament. But that's quite separate from the law courts. You really have no business making law at all. But they have, and they do, because there is this vacuum. And until Parliament steps up to the plate, this problem is going to continue and probably intensify. Because what it means is that there is a lot of injustice. In fact, in one case recently, the Supreme Court actually lectured the Court of Appeal on this very topic, saying the Court of Appeal had misunderstood the principles of vicarious liability. Misunderstood. One bunch of very senior judges lecturing another bunch of almost as senior judges almost as senior as themselves. And you've misunderstood the principle. How could that be? It's because, as Lord Neuberger said, there's a lack of reliable principle. If the principles were written down and legislated by Parliament, this problem would be at least lessened, if not eliminated completely. That's all for today. More next time.